Howdy, folks. This is Jamie Spencer. Welcome to the Texas NORML monthly meeting for all of our members. I am back again because not only am I a lawyer, but I've got my buddy, my colleague, my friend, Paul Quincy here with me. He's a criminal defense lawyer as well. We've got, I don't even want to think if it's 40 or 50 years of criminal defense between us, but it's something like that. Luckily, many of you guys have sent in questions already, so we're going to start the meeting after just a few introductions and announcements, handling those questions. Please feel free to put extra questions in the chat, either completely different topics but still related to marijuana law than the ones we're talking about, or if you want clarifications on some of the things that we're going to be talking about tonight. We have reviewed the questions, at least briefly. Some of them, and I'll let you know when, are in areas of law that definitely affect marijuana and how Texans should be able to use marijuana, but they might be like employment related. And so we're not employment lawyers, but we do know enough to talk a little bit about that. And the other thing that I like to say at the beginning of this is, I mean, at the end of the day, you really shouldn't represent yourself. I'm supposed to say all the stuff about this isn't technically legal advice for you specifically in the criminal case that you now have pending against you in some county or hopefully not district court, felony type case. But if you do want to ask those sorts of questions that relate that personally to your situation, just remember that, we're not privy to the police reports and the videotapes and the discussions with the prosecutors and things like that. But let's go ahead and start off tonight's discussion with one of the questions that was submitted. And what Paul and I will probably do is kind of take turns answering these questions, but we'll also have some commentary for each other afterwards. I'm going to start with the question that we got the most. It didn't come in verbatim the same for everybody, but several people this time asked, if I have a legal card from the Compassionate Care Program, am I able to tell my employer without being penalized or asked to take a drug test? So there you go. There's my caveat right off the bat that we're not employment lawyers. However, let's discuss this. The short answer is no, you probably are not able to tell your employer this without being penalized or asked to take a drug test. If you mean, can I get fired for it? If you think about it, it's perfectly legal to drink alcohol in Texas. If we had to swap alcohol and marijuana, I think many people here think marijuana would be the better one for folks. But there's no prohibition if you're talking about the drug testing portion of it. If you're talking about having it in your system at the time that you're working, that's really problematic because, obviously, you can get fired for showing up at 9 a.m. with alcohol on your breath or intoxicated on alcohol or those sorts of things. There's no prohibitions against that, even though the consumption of alcohol is legal in and of itself. Basically, I don't know if I should say it's my non-lawyer view. It is my lawyer view. But the short version that the employment lawyers that I talk to about these sorts of issues are, they say, Jamie, if the employer admits that they're firing someone because of national origin, creed, race, there are what are called protected categories, where if you can prove that that's the reason that you were fired, you should have some sort of remedy in Texas civil courts in terms of being able to bring a case. But I don't think that unless it's actually codified and made into some sort of a statute that says an employer cannot discriminate against people who use, you could probably put in almost any substance there, whether it was legal or illegal. Now, I think the answer is you may not have a remedy if you get fired. You shouldn't be fired, of course. That's my personal opinion. But Paul, do you have any extra tidbits on that?
Yeah, I do. Thanks, Jamie. So I'm a big union guy. I'm a union member. I organize with my union, trying to help other folks organize their workplaces. We have very poor worker protections in the state of Texas under Texas law. You may have heard Texas called a right to work state. I call it a right to work for less state. Basically, what that means is that we do not, under Texas law, workers do not have the right to collectively bargain. That is, form a union and bargain with their employers about things like salary and working conditions. So the way that translates to this is an employer can fire you for any reason or no reason, or refuse to hire you for any reason or no reason, as long as it's not one of those protected classes like Jamie was talking about. So in terms of, I'm not an employment lawyer by trade, but I know enough about Texas labor law to tell you that I mean, unless you have are lucky enough to have some kind of contract that governs what you can be tested for, the employer can hire you, fire you for any reason or no reason, and unfortunately that would qualify as just telling your employer you have a compassionate care card. So that's my take.
So maybe make discreet inquiries about, try to figure out how your employer figures out about such a thing. I mean, hopefully you wouldn't have to, you wouldn't typically talk to your employer necessarily about any of your other medications, right? I certainly don't think you have a moral obligation to tell your employer, and I don't think you have a legal obligation to it. So I'm going to, even though I'm not an employment lawyer, I'm going to pull something out of my criminal defense lawyer bag of tricks, and that is be quiet about it. Use your right to remain silent. Don't say anything. It's very often the best thing to do. All right. Paul, we're going to get this one pretty much every time, and it's good for us to go over it. I started with the first one, so I'm going to throw this one for you. What are the penalties for possessing marijuana in Texas? Asks Chad. Paul, I think you might be muted, or maybe I'm having an issue.
Sure enough, it's me.
Okay.
So it really breaks down into flower and concentrates. So if we're talking about just bud, anywhere up to 2 ounces is a Class B misdemeanor, and that means punishable up to 6 months in jail and a $2,000 fine. Between 2 and 4 ounces is a Class A misdemeanor, which is up to a year in jail and a $4,000 fine. And it goes up to felonies from that point. So 4 ounces all the way up to 5 pounds is the lowest level of felony. It's called a state jail felony, but it's still a felony. So all the nasty things you've heard about felonies apply, even though it's the lowest level. It goes up to, help me out here, Jamie, 5 pounds to
4 ounces to 5 pounds. And
5 to like 200 pounds or something.
Oh, yeah. I think it might be. Yeah, but here, and this is a great place if you don't mind me just jumping in just a minute and saying, first off, I'm not advising anybody to break the law. Let me make that very clear. But I will say that I think that it should be extraordinarily rare for most people, for 99% of marijuana users. It's hard to imagine a scenario where you would need to have more than 4 ounces. Is that an arbitrary number that some legislature set decades and decades ago? Yes. But, in life, you should be careful. And you should know that the distinction between 3.9 ounces and 4.1 ounces is night and day. Even though this obviously shouldn't even be a misdemeanor, getting up into the felony level really complicates things. Sorry, Paul, go ahead.
Oh yeah, well, like I said, it goes up higher into felonies from there. So that's just talking about bud. Now, anything that has THC, now under Texas law, it's Delta 9 THC that is specifically prohibited. Every few months, it seems like the Department of Health and Human Services or whoever it is that it regulates, just can do regulations rather than laws to say what can be sold and what can't. It seems like they try and ban THCA, Delta 8, and different things, and that's at least here in Travis County, of course, I'm talking about Travis County. Your mileage will vary in every other county, but there has not been much in terms of regulation. It's for sale pretty much anywhere. But because the law applies to Delta 9 THC, and in your other counties they may not care, what other kind of cannabis it is. THC concentrate is always a felony. It starts off as a state jail felony. So when you're talking about THC concentrate, it's not considered marijuana under the law. It's considered a THC concentrate, which is a controlled substance under the Controlled Substances Act. And so that means that that under a gram is going to be that lowest level state jail felony. And then it goes up with the penalty groups, just like cocaine and other controlled substances. It's going to go up to between 1 and 4 grams is a third-degree felony. Then 4 to 200 grams is a third-degree felony, and so forth.
Right. And let me add on a little bit about different counties. So Paul and I have both practiced in primarily Travis County and Austin. We're coming from you live from beautiful Austin, Texas, the capital where the legislature is, where we've both been trying to convince those knuckleheads that they need to do the right thing. But we also practice, if you go north in Austin on I-35, the first county you're going to hit that's not Travis County is Williamson County. And they're not quite like this anymore, but certainly 20 to 25 years ago, they literally liked to brag that they were the harshest county out of all 254 counties in Texas, right? And so there were times that Paul and I represented marijuana clients where, to be just brutal about it, it didn't necessarily even take much legal skill to get a possession of marijuana case dismissed in Travis County when it's almost completely impossible in other places. This is, this is lessened somewhat, but 254 counties is a lot. And there's still a lot of people out there that think this law is worth prosecuting to the fullest. All right. Let's.
I'll do one more thing real quick, Jamie, about just consequences. So the question was, what are the penalties? Now we're talking about legal penalties. Those are really kind of the least of your worries sometimes when you have a criminal record. So once you get arrested, if you are booked in and your fingerprints are taken, you have a record. A lot of times people will ask me, because primarily what I have done for years in private practice and now do at the Travis County Law Library, is I help people expunge and seal their records. And so a lot of times people will ask me, is this on my record? And my answer is, if there's a public record of it, then you have a record that can be used against you. So even just being arrested creates a record with the county and the DPS and the FBI, and your fingerprints are shared all through that chain. And the only way that you can get your information taken completely out of that system is by having the case expunged. And you can only have a case expunged if it's dismissed. And there's a variety of ways you can have it dismissed. But what I'm saying is, when we're talking about like criminal penalties, I mean, I talked about jail and fines, but there's also all the hassle of probation. A judge can order any reasonable conditions of probation, which is going to be a fine and community service. And honestly, in some of these smaller counties, anything the judge can dream up. So let's just keep in mind when we're talking about penalties, there are a lot of things that can affect your life with these kind of cases, with any kind of arrest, not just marijuana. So that, I think that bears remembering.
Absolutely. That is part of the punishment, is that it can potentially follow you around for life. And sometimes there are jobs that you might want to be employed at, where they have some sort of internal rule that says, okay, you can have a Class C traffic ticket, but you can't have anything higher than a Class C. So you go to jail one night for possession of marijuana. They give you a personal bond the next day. You go to court. They say, remember that one day in jail you did? Pay $200 in court costs, and that one day in jail is it. You don't even have to do probation. You don't have to, go back to jail. Those sorts of things. I mean, to some extent, that might be a good deal. It's better than being on probation for years and all this other things. But it's a conviction either way, and yeah, that conviction is going to stalk you. Paul's right. All right. So I'm going to take what I think is the toughest one for me to answer, and then I'll throw it to Paul. THCA is flooding the market right now, says Jeffrey. Do you see that THCA being banned at some point, or is it already illegal? I've got a lot of complicated thoughts about this. And some of them, to be really brutally honest with you, I'm not necessarily willing to say in a public forum. For example, hypothetically, if I knew of ways that the state could try to use certain statutes to prosecute clients for marijuana crimes, I would not speak about it in public. And so I'm trying to use some discretion here, but I will put it this way. It's even if we have laws that we write every 2 years for 140 days. 140 days is how long the legislature meets, and they come and they write new laws, and they write new laws about everything all the time. And what happens is there are conflicting laws out there. So let me start with this. Is it illegal now? Honestly, I think the answer is maybe, but for the most part, no. My experience, or practically no. Although this may get back to the discussion I had with Paul about different counties may feel differently about it. Once the hemp law, the farm bill, all of those things came in and caused problems for prosecutors around Texas, I think a lot of county attorneys' offices, misdemeanor prosecutor offices, decided that they would use this almost as an excuse for why they wouldn't prosecute marijuana cases, which I'm glad. That's great. That's great for those counties. And some other counties have sort of knuckled down. So I want to start with this. I have absolutely no doubt that if you're caught with THCA, a prosecutor could initiate a case against you. And then you'd have to deal with it, even if you end up winning it. I think that a system where the legislature goes in and pretends that they understand the chemical combinations of all of these different things that we're doing with THC, that businesses are doing to try to comply with the law, but still be able to have clients who need this medicine and follow it. All of that is, there aren't any absolutes. I mean, I guess the thing that I point to is, let me think. That's Tommy Chong. Tommy Chong, this was probably 20 years ago. Some prosecutor, and if I remember correctly, it was Pennsylvania, it may have been somewhere near Philadelphia, decided that Tommy Chong, even though he hadn't been to Pennsylvania in years, that he should be prosecuted for the bongs and drug paraphernalia that he was selling and those sorts of things, right? Is that reasonable? No, she wanted to make a name for herself. So I'm very cautious about telling people on these the things that aren't Delta 9 THC. I think we have a good argument for you in court as your lawyers. Not me personally, but you understand what I mean. But I don't know that we know where that's going to end up. Do you see that being banned at some point? Well, I have no doubt that there's some legislator who wants to do it. Does that mean that they're going to be able to? I mean, we're going through this really interesting battle right now where we're sort of relaxing some of the criminal rules when it talks about marijuana, and yet we have this legislature that still likes to go out and complain about things that are very similar and just substitute one bad law for another, or substitute one bad law for 5 more bad laws. I hope it's not specifically banned. We haven't seen as much of that as we could have over the last couple of legislative sessions, would be part of my answer to that. So anyway, I've talked for a long time about it. I've used a bunch of lawyer weasel words, and I think it's possible I didn't even answer your question, but hey, why don't I throw it over to Paul to see whether or not he has any additional ideas on this subject?
Well, same. I don't know exactly what the status of the regulation is. So it's not in the Controlled Substances Act. To change the Texas Controlled Substances Act, would require a bill to be passed into law by the legislature to amend that statute. But there are also regulations on what can be sold, and that's what you see a lot in just different things that are not under the Controlled Substances Act, but still can't be sold. I say when in doubt, treat it like it's illegal, because like Jamie was saying, they may have a great winning defense for you. By the time your lawyer is defending you, you already have a record. So just for you're living your life, treat it, if there's any question, treat it like something you don't want the authorities to know about.
And I'm glad you brought that up. Let me talk a little bit about this wasn't submitted, but it's sort of a hidden question within the last question that Paul talked about. Do I have a record, Jamie? Hey, Jamie, what's on my criminal record? I hear this sort of thing all of the time. And one of the first things that I talk about is there's really no such thing as, there's certainly not one central database for your criminal record where every governmental agency can go and figure out everything you've been arrested for your entire life. Even this far past 9/11, and I've been saying this for decades now because we're more than 2 decades past 9/11. They've been saying they're going to put a system together like that, and they haven't done it. So in what Paul was just talking about would not be a record of a conviction, right? Because remember, later on in life, you get the lawyers win the case for you. Okay, yay, good. We got a good outcome. But there are records of just the arrest itself. And really what there are is there's a bunch of incomplete records. In other words, an employer might find out about an arrest, but not the dismissal. And guess what? Most people in most criminal cases are convicted of whatever. I mean, the majority of people are convicted of all the various crimes that we accuse people of. It's one of the reasons that the United States is the incarceration capital of the world by far. It's not even close, right? So, yeah. Paul, treat it like it is illegal. I think that's how you put that. How did you say that? I like that.
Yeah. When in doubt,
when in doubt,
illegal.
No harm, no foul if you treat it like it's illegal.
I'm gonna take Jamie. We got a question in the chat. I want to take real quick before we get back to the questions. It says, what is the federal rescheduling from 1 to 3, from Schedule 1 to Schedule 3 for THC mean for Texas? Asked by Stephen Helms. Thank you for the question. Short answer is that even if it is changed in the Federal Controlled Substances Act, Texas can still make it illegal under the Texas Controlled Substances Act. So in terms of your federal charges, it's going to change that. But the kind of state level charges that Jamie and I are talking about, it will not mean anything immediately. I think it would be favorable to the trend of lowering the schedule in Texas law, but it wouldn't have any immediate impact on these state cases like what we're talking about. Does that answer the question?
Oh, I think it did, yes. And I mean, if I can add on to it a little bit, if you'll think about, many people are sort of familiar with the differences that many legislatures, federal and state legislatures, made in the 80s and 90s about crack versus powder cocaine, right? And, what they did recently a few years ago is they very slightly reduced the disparity. Okay, they did technically make how much more you could get for the same amount of the substance. Like sometimes you needed. Let me look it up real quick what that ratio was, or maybe I'll do that if I pass this over to Paul since this is live. But yeah, I agree with Paul. Rescheduling from 1 to 3 is technically better, right? It's objectively better that it's not as bad a drug, and getting punished 9 times as badly for crack cocaine as you would powder is, I guess, objectively better than being punished 10 times greater for crack cocaine than you are powder cocaine. But we're talking about tiny band-aids. I'll just tell you my personal opinion. I think that politicians absolutely know, not just the majority of Texans, the majority of, it's a super majority. It's somewhere between 85 to 90% of Texans think that people going to jail for marijuana is wrong and we shouldn't do it. And we've been over a majority on people feeling that way for it's got to be more than a decade. I couldn't tell you exactly when we hit the 50% mark. And by the way, when I started practice about 25 years ago, we weren't at 50%. So, incrementally things do get better. But a lot of times I see these things, and to me, it's a way for a politician to pretend that they've done something for a particular constituency, but because it really doesn't change anything, they don't get flack for it. Paul, I didn't know if you had any further comments on that before we went to
just one thing. You were talking about the crack to powder cocaine disparity. It reminded me of something that I wanted to say about controlled substances and THC concentrates. So when we're talking about the weight that applies and how high of a felony it is, the weight of the controlled substance also includes any adulterants or dilutants. So anything that the cocaine is cut with, anything that the THC is baked into. For instance, I think it was like 5 or 6 years ago, they charged a kid for bringing with a first-degree felony in, you guessed it, Williamson County, for bringing a thing of pot brownies to school, and they included the weight of the brownies in the whole thing. So that's just something else to know. We were talking about just a matter of grams, but it also includes anything that it's mixed with.
Yep, I certainly do remember that case, Paul. And please, everyone, feel free to bring it up to anybody that you feel like you need to convince that these penalties are too harsh. This was a 19-year-old kid that put pot in some brownies and was facing a first-degree 99 or life sentence potentially. That's beyond ludicrous. I mean, the fact that we are doing this to our own children is shameful. Do you have any thoughts? Next question dropped in the chat. I'll do the chat one since I know these folks are here. Do you have any thoughts on growing, possessing, and consuming solely on my own property? Yes, and my thoughts are that I have represented people for doing that, because it seems like the question is asking me to I mean, you're putting yourself in danger because you're breaking the law. And remembering that I'm not here because I am licensed by the State Bar of Texas, speaking as a lawyer, I'm not allowed to encourage you or help you to break the law. So that's not what I'm doing. But my thoughts are that sounds a lot safer than smoking a joint, walking down the public street. But I sometimes wonder, I'm going to say this and I'll pass it over to Paul for comments on at least this part of my answer. I mostly see the people who get arrested, right? So do I really know, even though I've represented people who home grew and all sorts of things like this? Yes, it is possible. There's no way for me to know how many people aren't being arrested for those sorts of situations, right? So, I mean, you're not going to call a criminal defense lawyer about your pot plants in your backyard until the police show up because the neighbor complained about them or however it was that it came to law enforcement attention. So I sometimes hear lawyers talking about like their own personal experience with cases in terms of percentages and what kinds of cases there are. But when you're talking about this sort of thing, the unknown is how many people aren't getting arrested for it. Anyway, Paul, anything on that? You're muted, buddy.
So my thoughts is whatever you're going to do it carefully. Growing has always been kind of a low risk, high reward area for folks selling, just because there are things you can't control everything, but you can control what goes on in your house, and you're not subject to just being pulled over. So in terms of, now you got to remember though, the law doesn't make any distinction whether you're in your own home or not. Obviously, I agree that you should be able to do that in your own home, but the law is the same whether they find it in your house or they find it in your car. So it's like, I agree with Jamie. It does seem safer, but it also depends on how much you want to how much it's relatively, what I was going to say is relatively low risk as long as you can control who knows what's going on in your house. So it's not like just being subject to being arrested anywhere out in the world, but there's always only so much you can control. So so be careful.
All right, great, thank you. So Mary Jo asked, and let me just let you know, Mary Jo, I'm probably going to give you a disappointing answer because your question is complicated. It is regionally. There's some issues. I don't know what county you're in and those sorts of things, but let me go ahead and read your question. What can I do about the county permit office refusing to allow a meter put on a building to be used for licensed hemp growing when it's already approved by my energy company? Now, I'm going to make up some facts. I'm going to throw in some extra facts into your example just to try to talk my way through this to give you some ideas of what we're looking at here. And I understand if you want to drop them again in the chat or whatever, I might be able to sort of revise that answer. But I mean, the punchline answer is that sounds like the sort of thing that you probably need a lawyer for, a local lawyer. And I don't even know if you need a criminal defense lawyer for that, because you ever hear us talk about or politicians, we're a nation of laws, we're a nation of laws, we're a nation of laws. Yeah, we got more laws than we probably have cockroaches. And those laws can blend together and work well together sometimes. And sometimes they're opposites and they can completely conflict. So I can certainly imagine a scenario where you get whatever the legal permission you need to grow hemp. And I'm not going to tell you that I'm an expert on setting people up with that, right? Because I'm a criminal defense lawyer. That's like a business lawyer type thing. But could there also be regulations about how much energy you can use in a certain neighborhood, depending on how things are regulated? Not an energy lawyer, but I'm just saying, in other words, there could be, just because you have permission to do it legally doesn't necessarily mean that you get to have a permit for it. And to be super clear about this, absolutely not my area of expertise. I've lived in Travis County for 30-something years now in Austin, Texas. I would not be able to answer this question specifically enough for you, even if it were in Austin, because I don't have any idea what the rules for getting this extra meter or whatever is put on your house are. It's not the type of law that I do. So, you can get out the yellow pages. I sound like an old man saying that. And call around, see if you can get a consult with a lawyer and those sorts of things. But that's a tough question for me to answer specifically. All right, I can't even remember. Did I throw this to you, Paul, already?
No, I'm glad you didn't.
Okay, let's go to the next one.
Better than I could do.
All right. Just calling up the questions again. Oh, I love this one. I am going to throw it to you. Raven asks, my city has a decriminalized misdemeanor marijuana possession law. Can city police or state troopers search my vehicle based on smelling marijuana as probable cause? And just to give a tiny bit of backup before I throw it out to Paul, for those, first off, don't hot box your car. Don't hot box your car. Your car's going to smell like weed even when you don't have weed in it. And you're just going to get harassed more by the police. But could there theoretically be a situation where somebody had a substance that the police officer thought that they could smell and that they were going to claim that it was going to be marijuana? The general rule is going to be that the odor of marijuana is going to allow a search. However, and I'm not an expert on exactly which states, this is an issue that's being litigated in many states about this issue about if everything that smells like marijuana is illegal, then the smell of marijuana is clearly going to lead to probable cause. Is there some amount of substances that could smell the same but not be marijuana? Of course. But then we get into a definition of probable cause in terms of whether a police officer can get into your business, and that's a very low legal standard. And I said I was only going to talk for a little bit. I've gone too long, so I'm going to pass it over to Paul for his thoughts.
Okay, so whenever somebody asks me, can the police do this or that? My answer is always yes, because there is no accountability of police officers for super egregious things, and certainly not for their violations of your rights. I'm not saying you have no recourse, but in terms of whether they can search your car based on the odor of cannabis, by the time your very good lawyer gets to make a very good legal argument, even if it is sustained, you already have a record. You've already paid this lawyer all this money. So the answer legally is there are some very good legal arguments that can be made that because hemp is indistinguishable from Delta 9 THC, and you can't tell what the percentage is, whether it's legal or not, they can and will search your car based just on that. And let's say they do that, and you go in for you want to get your lawyer to suppress the evidence, and you have a hearing about probable cause. Well, all it takes, apart from the smell of marijuana, is another what probable cause is specific facts and reasonable assumptions from those facts that lead them to believe that you're involved in some criminal activity. So all they have to say, apart from the odor of marijuana, is you were nervous. You made furtive movements. Your eyes were glassy. Eyes look like glass. That's why they make fake eyes out of glass. They can put in their report any number of other facts besides the odor that would lead the right judge, or the wrong judge in this case, to believe that probable cause did exist. So there's a lot more that they can use, and even if it's not in their offense, testified as on the offense report all the time. So just because there are, like Jamie was saying, other things that do smell like illegal cannabis, that does not mean that they don't have probable cause based just on that smell.
And again, not an expert, but just following up on some of the things that Paul brought up. First off, I love the can the police do this question. In fact, it's a pretty common experience for a criminal defense lawyer to have somebody come into your office and say, hey, here's what the police did. Here's what happened to me. First, they did ABC. Then they did LMNOP. Then they did XYZ. Can they do that? And the smart aleck in me wants to say, I don't know, buddy, you're the one that told me they just did. But I mean, I have sort of a point there when I say that, which is, I mean, what you're really asking is, are we going to have a remedy? Does this sound like a clear dismissal to you, in this first 30 minutes of talking to you as a client? And even then, I have to tell you, I don't have the police report yet. I don't have the videotape yet, but here's a plan for how we're going to get you into the best possible position to get a dismissal, or if a dismissal in that particular county, maybe it's a felony or whatever, isn't reasonable, maybe a reduction to a misdemeanor. Here's the plan for how we're going to do it. Okay, not just legally, but sometimes what Paul and I would call a Boy Scout packet. Maybe have you run out and do some community service, or letters of recommendation from people, try to persuade the prosecutor that you're somebody that should be let alone. But can the police do this? Yeah, they can. They do. They have guns. And then at the very end, Paul was talking about the wrong judge, which makes for a nice intro into this question from Michael. Do judges have the authority to disregard the Compassionate Use Act and deny someone from accessing their medication? Typically, when I hear this question, it comes in when I get more details about this question. It's typically if a judge puts me on probation for any criminal offense, it doesn't even have to be drug related. Can that judge then say, number one, they're allowed to drug test you during probation? Okay, they absolutely can do that. And number two, they almost definitely will at some point, maybe not every month, but they're going to do it. Can the judge lawfully revoke your probation and put you in jail for up to that 180 days, for example, that Paul was talking about on a Class B misdemeanor in Texas, because he said that you cannot test positive for THC, but you're part of the Texas Compassionate Use Program? Yeah, I mean, what I would like to think would happen is that your lawyer would find that out from you beforehand and really try to see if there weren't some sort of creative way to fashion a plea bargain if a dismissal couldn't be had, that could be allowed. But are there, I mean, I've certainly run into this situation. I know Paul has, where we have to tell people, listen, man, you're just going to have to stop smoking pot because it's going to come up. So the answer is, this is a unfortunate but easy, simple answer. Yes, if that's what you're talking about. Now, I don't know what other circumstances it might apply to. But in that context, the answer is yes. Paul? You're muted, sir.
Thank you. New platform, but I do that on Zoom and Skype and whatever else too. Whenever somebody asks me if a judge can do this, my answer is yes. There is less oversight of judges than there is of cops. And if you wanted to get some relief from the judge's decision to send you to jail or revoke your probation for testing positive, even though you have a compassionate care card, that would be a very long and expensive legal battle to appeal the judge's decision to revoke someone's probation, which in my understanding is an abuse of discretion standard, Jamie.
That sounds right.
And it would be hard to find a judge that's going to second guess another judge. Well, it would be hard to find a judge with the authority to overrule that judge that would make that call, I think, especially in a state like Texas, where the judges, the higher the authority, the more conservative they are. That's just how it is. And you're going to have your conservatives on the lower end too. But in general, in our appellate courts, there are 15 state appellate courts, and they are mostly very conservative judges. So whenever you're going to ask, can a cop or can a judge do something, who's going to stop them? What is the oversight? What kind of accountability is there? And there is none. So yeah, just can a judge do it? Yeah, watch them.
Those are some great points. They sparked some additional ideas that I want to play off of that. I also want to tell folks that we have, we're way past half of the meeting. We may have a few minutes left, but I'm wrapping up the questions. So if you have any, please put them in chat and they'll be forwarded to me. Right. So what we're talking about here is the trial court judge, right? You're unwisely walking down the street, smoking that doobie. You get sent to the jail. You bond out, hopefully. Usually in most places, you're going to be hopefully able to bond out pretty easily for a simple Class B possession of marijuana charge, although that's not always the case. And then you're given a court date. You go to court and the judge says, yeah, I heard everything your lawyer said, and I'm still not allowing you to have any THC in your system for the term of this 2-year misdemeanor probation. Well, you've already failed to convince that judge. So what we're talking about here is appeals. And I do think in theory, I kind of want to talk this through. I think, I'm sure that you can challenge conditions of probation before you're revoked. You would need to do something called a writ of habeas corpus, most likely. Interestingly, well, I don't know if it's interesting or not, but I've been doing a ton more appeals over the last year and a half. And this is something I knew, but let me put it to our audience this way. If it seems like, so here's the trial court, then there's an intermediate court. For me in Austin, that would be the third court of appeals here in Austin. And then there's the court of criminal appeals. Anytime you're convicted here on the lowest level, you have an automatic right to appeal at least once and complain about something. And then sometimes if you still lose, you can go to this higher court, Texas Court of Criminal Appeals, and say, please take the case and listen because I'm right and they were wrong. It's very hard to get that done, even to be heard at that point. If it seems like it's difficult for the criminal defendant before he's been put to trial and convicted, and it is an uphill battle. Each step up that ladder gets harder and harder, not just for the reasons that Paul was talking about, although those are valid. It's actually an issue of the law. Once you're convicted here, the appellate court, I guess the short version is they start off assuming that everything went right in trial. That's kind of the posture. That's not the legal version Those aren't the legal words for it, but there's an overwhelming assumption that everything went correctly. And there is a real hesitance to change anything that happened at the trial court level in the appellate courts. What they typically try to do is they try to say that somehow you made some sort of mistake in the process where they're not even going to listen to your claim. Seriously, they won't substantively listen to your claim. And then if they substantively listen to your claim, they're going to say, well, you know what? Your lawyer didn't raise it properly. He waived the issue for some reason. It's not something we're going to even look at because it's not an issue that we're going to take up. Or even if they decide, okay, we do have to actually answer this, not so much in the probation case, because that deals with whether or not it's a reasonable condition of probation. But generally speaking, yeah, every time you go up that ladder of trying to go to a higher court, literally whoever won before is in a even bigger winning position than they were at the beginning. Hopefully that makes sense. Paul, any last comments on that one?
No, I don't think so. We do have one more question from the prepared questions.
Go for it.
Beforehand. So this is Riley asks, I bought THC wax in New Mexico earlier this year, and later it fell into my vehicle and got lost. Me and some friends went to Big Bend National Park and were stopped by Border Patrol on suspicion of illegally crossing the border. At one point during the detainment, a dog alerted on the wax. I was arrested and my guns in the vehicle were confiscated, but they let my friends go. 10 months later, I haven't heard anything further, and my case is being worked on by the Uvalde Sheriff's Department. What action should I take to get my guns back?
Yeah,
go for it. Go ahead.
Oh, well, I will say this. I read that, obviously, in preparing for this, and I was expecting a different question at the end, because I'm going to take a stab at sort of not answering your question. I mean, first off, I'm biased, right? Get a lawyer, right? That's going to be some of my advice. But I definitely think in this situation, you would probably need to do that. Worse, though, is that what we're talking about here is potentially a felony. The statute of limitations hasn't come anywhere close to running. And I definitely think there are some law enforcement communities, and by community, I include the prosecutors, not just the cops, right? The prosecutors, the judge, the entire community are, how do I say this? They're vindictive at times. Or maybe it's just, hey, Jamie's asking for his client's guns back. Oh, let me go take a look at Jamie's case. Oh, here's the file. Oh, holy crap, I forgot to indict this. I tell you what, I don't want to give Jamie's client his guns back. I'll take his case to the grand jury. So I think there's some proceed with caution here, and what you need is a local lawyer. And I'm not talking about because they're bribing the judges, passing them money under the table, and those sorts of things. But there are basically 254, actually probably 508 prosecuting systems with the county attorney's and district attorney's office all over Texas. And there's things that, like in some counties, you might be able to raise this without that retaliation. But it would take somebody with local knowledge to know the best way to get that done. Paul?
My actual answer to it, I've never practiced in Uvalde County, but I have practiced in some smaller counties. And in terms of getting your guns back before the case is disposed of, I don't know that you would necessarily want to do that. And the reason I'm going to give you is bribery is illegal, but you can always forfeit weapons as a condition of probation to negotiate against other conditions of probation. Sometimes it may be if you have nice enough guns and whoever it is in Uvalde, the detective working the case, would really like for you to forfeit those guns, because God knows what happens to them after they're forfeited to the sheriff's department. You may want to have that as a bargaining chip. I mean, I've seen like lots of weapons charges are, at least here in Central Texas, a lot of times if you forfeit the weapon, they will dismiss the case. Now, I've got some, even though I'm not a big gun guy, I've got some constitutional problems with that model. But in terms of your specific case and what is going to benefit you personally, I would let them hold on to those guns and see what kind of a bargaining chip it may be in terms of what the outcome of the case is. But I absolutely agree with Jamie. Not being indicted is way better than being indicted. So don't poke the bear. And if they forget about you for 3 years, you're good. It may, and these, like for instance, Hayes County, just south of us, San Marcos, is not the smallest county. It's got some pretty decent sized towns in it, but they have a huge backlog. It takes them sometimes, the statute of limitations on a misdemeanor is 2 years, and for a long time in Hayes County, they would take almost that entire 2 years before they charge somebody, and then once they charge you, the statute of limitations stops running. So 10 months on a felony, which the statute of limitations would be 3 years on that, doesn't sound like a super long period of time, but every county does things a little bit differently. And that's why Jamie's suggestion about getting local counsel, yeah, as local as you can, just because they know the ropes, they know what's possible, and they have usually, as harmless and innocent though it may be, they have relationships with the people who are making these decisions.
Right. And as a criminal defense lawyer, what are Paul and I looking for our clients more than anything else? A dismissal. That's really the top charge. And I really like a couple of different things that he said there. First off, in terms of Hayes County, I literally in the last few months had a discussion with another Austin/San Marcos Hayes County criminal defense lawyer buddy of mine, where he was at 23 and a half months, 2 years statute of limitations for misdemeanor, as Paul said, 2 weeks away. And we were talking about the possibilities of, the statute of limitations running. Client got charged the next week. So you do need to be careful about that in terms of statute of limitations. The other thing is that I wrote down that Paul was saying was the part about forfeiting it for a dismissal. Now, I have had clients tell me, listen, Jamie, this was my some sort of great-grandfather's gun that had been in the family. I am also not particularly a gun expert. I can't remember why this was a particularly valuable gun. But in terms of what the price would have been on the market, but it was more like an emotional attachment, right? Okay, I get that. But let's talk about that second. Let's talk about the other issues first. Let's say you don't have an emotional attachment, and it's a gun that's worth $400 or $500. As Paul talked about, you can't bribe them. You can't say, hey, prosecutor, what if I give you $500? Can you dismiss my case? But you can say, what if my client forfeits the guns? Can we get a dismissal, right? Which is effectively the same thing, but it's just part of the going back and forth when it comes to that. It's not specifically prohibited as the direct money bribe would be. And so, yeah, leaving that out there as a possibility, I think that's definitely something that, again, like Paul said, local lawyer, find out what you need to do there. Now, my job is to serve my client. If it's more important to my client that he gets his great-grandfather's gun back than the potential of, being indicted for a particular case, that's a long conversation to have with a client, right? We don't have time to kind of go through all of that right now. But that's a perfectly valid thing that a client can do, as long as they have a lawyer that's truly able to kind of tell them, well, okay, but here are your percentage. You can't give exact percentage chances, but here are the chances that we're poking that bear that Paul was saying don't poke. So be careful out there. All right. I think we have reached the end of our questions. It's always fun for me to have Paul here. So thank you very much, Paul, for coming. I don't see any extra questions in the chat, so we will go ahead and wind down. We will be here again. Let me get the exact date for everybody. The first Wednesday is January 3rd, so we will be doing January 3rd. Just like this, 7 p.m. Please log in. And obviously, NORML is here for the same reason we've always been here. We want cannabis consumers in Texas to be able to use the medicine that they need without government interference. So please, keep tabs of what we're doing. Find out when we have alerts to let you know when the legislature is meeting, how you can come down. We give little seminars on how you can come down to Austin and actually speak with your representative at times on our lobby days and things like that. So if you're interested in joining this movement and changing things for the better, please keep us in mind. We appreciate the fact that you've been here tonight. We are going to be so there's also primaries that are going to be coming up in March in Texas, and we will be putting out a primary voter guide in February. Now, we are a nonpartisan organization, so we do not endorse people. But what we are allowed to do is we can tell you, and this is what the voter guide primarily does, what the various candidates' positions on this important topic are, so that you know and you get to factor that in when you make your decision about who to vote for, especially in your local and state races, because it's going to make a lot bigger difference there. All right, everybody, again, we appreciate y'all being here. This is always fun for me and Paul. And that's it. Good night, everyone. Have a good night.
Good night.